Hello everyone, welcome to Chasing a Murder. We have two videos for you today. How about that? So, John Pryor, Chad Daybell, defense attorney for what we call the Lori Vallow and Chad Daybell doomsday couple case, put in a motion to withdraw from this case, which is quite interesting considering all the trouble they caused the state. Rob Wood, if y'all remember that. Not to mention as much time as Pryor has put into this case. Now, he knew from the very beginning that Chad Daybell didn't have much money, so that's also another interesting thing that I think now that this motion's come up. So today they were actually in court and they discussed whether or not John Pryor would continue to be Chad Daybell's attorney.
Scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then, yesterday on the 17th of January, filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order, and I've provided copies of that to counsel, but it does have some relevance to today's proceeding.
Filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time.
So one of the big questions, why is he having such a difficult time finding someone to hop on board and help him out? Well, it might be some of the trouble he caused with the state earlier on in this case. You don't remember again, they were trying to get Rob Wood thrown off the case. It also could be the fact that his past is not so pretty. John Pryor is not considered to be one of the most loyal and honest attorneys around. Let's not forget the fact that we know there was a point to where Chad was struggling to make payments to his attorney, in which we heard that Chad basically signed over the family home to his attorney. At that point, John Pryor realizes the predicament that he's in, that once that house is signed over, there would be no more money coming to him. I wanted to share that before we move much deeper into this courtroom drama, I'd have to call it.
Finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors, and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in, Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, you know, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money.
Okay, so that's important to know that he says, you know, he wants to stay on this case and that he doesn't care about the money. That absolutely makes no sense for what he's going to tell us next. So why is it that he has a motion to not represent his client any longer? Is this a strategy for him of some sort? I don't understand it. I don't think any of us do. But let's listen in just a little bit more.
Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So,
right, and that's correct, Judge.
This is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
You know, you must know that John Pryor always has a method to his madness. There's no way in heck he could have let this go on this long and then say, you know what? I'm not getting paid. I don't want to do this anymore. The fact that the judge says, you know, what you're saying to me right now doesn't match what we have on this motion is very concerning and interesting. He sounds like he's all for doing pro bono work for his good friend Chad Daybell, but at the same time, he isn't. And a lot of it is, it seems like he's saying, look, I'm having trouble finding help. If I don't have help for this case, this could make it unfair, basically, for Chad Daybell. And what happens if he feels like he didn't have enough help to help his client? They get through trial, then they come up with, you know, a verdict, and let's say it's guilty. What happens? Is there something that John Pryor can fall back on to appeal or to even go even further? Let's listen in.
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work.
So he's claiming that Chad Daybell doesn't feel comfortable having prior work for free, basically. Now, this is something that Chad's always been able to do for people, is make them feel as if he cares about their general well-being. This is how he got the few followers that he had. But is that the truth? The truth is John Pryor using that as an excuse to bring forth this motion and to find a door to escape this very complicated case. I'm not certain. What do you guys think? Share your comments below.
And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be.
Okay, guys. One thing you need to understand is John Pryor is solely responsible for making sure that he had enough help to get this case in the direction he wanted it to go. And he says he's done that, but he's not had good luck at it. But it's been how many years? And they're still waiting on approval for this one attorney that he was going to bring on the team. This is a concern for him. Wow, this is like last minute stuff here, guys. Even if the guy jumped on 3 weeks ago, would that make a difference?
Be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial.
So there you go. He says that he's going to wait. He's going to try to do what he can, even if he's denied to get off this case. Whatever he can to defend his client, whether he gets paid, he doesn't get paid, whether he gets help or doesn't. So it almost seems like an outcry for help that John Pryor feels overwhelmed and stuck. So what can happen if John Pryor is not prepared? According to a few online sources, if the attorney is not prepared and a judge tells him to go ahead anyway, that could be a grounds for appeal. Also, a defendant can bring the matter to the attention of the court by arguing that they are receiving ineffective assistance of the counsel. However, proving ineffective assistance of counsel is not easy. Even if a defendant can show that their lawyer's performance was deficient, they must also show that that deficient performance prejudiced the outcome of the case. Lastly, the right to an adequate representation doesn't mean a perfect representation, but a lawyer's incompetence may justify a court overturning a guilty verdict. So you have all these things that you can look for when you put a defense attorney in a corner. John Pryor just repeats himself on how he thinks it's not fair and how he would love to be paid.
But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No.
In 2515, there's a special sentencing proceeding, and Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue, because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be.
Okay, we're going to skip a little bit here, guys, because they basically, go into privacy to talk about this. To be honest, a lot of people are trying to figure out, why even do this? Well, it seems to be a strategy, in my opinion, that John Pryor is using because he is struggling trying to find help. So he can say, yeah, I'm struggling, but also he knew himself that if he couldn't get the help, well, it's his responsibility. As far as I'm aware of, at least, I'm not that great at law, that, the ball's in his hands. He could have said no or yes. So is this going to be a way to either push court out further or to get an appeal? We don't know. But anyways, they come back from recess.
That you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client. Although it may be difficult and he apparently will not be able to be compensated, it's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw. Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that, and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today, and I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge. Thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
If you want to talk about the agreement, this is for anybody.
Okay, so there you go. So anyone that knows John Pryor, he's quite persistent and will fight aggressively when he wants a certain thing, and that's not something he fought too hard. So in my opinion, that is just John Pryor's another tactic he's using. Also, what we notice about Chad Daybell is he sat there quietly, very patiently, and didn't show any kind of uncomfort for what they were talking about in court today. So that led me to also believe that this was just a tactic. Also, we notice his physique today. Looks like Chad Daybell's actually put on some pounds in jail. Kind of gives you an idea of his mindset is in a different place than when he first went and was arrested. I noticed a lot of comments on this that people were getting kind of upset and shocked by everything that was going on, but this is just something you can expect as courts draw nearer. If anything, you might even, I keep thinking there might not even be a trial, that there might be some type of plea deal coming up, considering the fact that this is a death penalty case, that the death penalty is still on the table for Chad Daybell. Through prosecutor mistakes, Lori Vallow, she had the death penalty taken off. She will remain in jail for her entire life. But right now, she has 2 trials coming up herself, one for her husband, Charles Vallow, and her nephew-in-law, Brandon Boudreaux. So share below, guys. What do you think is happening? Do you think that John Pryor is worried about the money? Or do you think that house that he got from Chad was enough payment and this is just a tactic? So I want to say also before I go, guys, do not forget about these faces we have out there. These children that continue to go on missing or their cases kind of in a stall. Monkey, Jasmine Robinson, and Dulce. Share their face today on your social media. I love you guys. Thank you so much for your support, and I'll see you guys soon.